Welcome to the O'Connor Elder Law channel. I'm your host, Melissa O'Connor. I'm a Florida-based elder law attorney who does estate planning focusing on long-term care needs, commonly referred to as Medicaid planning, and I do probate, and I do it well. Today I wanted to talk to you about durable powers of attorney and how they relate to revocable trusts. So many times your revocable trust will say that if a person is incapacitated, if the trust maker is incapacitated, that the trust cannot be amended at that time. And sometimes married couples will have joint trusts, meaning that there's one trust and both the spouses are the trust makers of that trust. And so what happens when one trust maker becomes incapacitated and the other trust maker is still of sound mind and they want to change some of the terms of the trust? What happens is, for them to be able to change the terms of the trust, many times they will need to have a good durable power of attorney in place that says that the agent under a durable power of attorney is able to make modifications to the trust. If your power of attorney allows for that, and your trust document allows for an agent under a power of attorney to make amendments on a trust maker's behalf, even if they're incapacitated, then the trust could be amended even if there's incapacity. This is an issue that I recently ran across in my office. A couple, they made a revocable living trust, and people age, people pass away in the family, and some of the people that were set to inherit in the trust are no longer appropriate to inherit simply because of different issues, health issues. We don't even know if, we suspect that the trust makers will outlive this person. And one of my clients wanted to change the beneficiary to a charity instead. They were like, let's just leave this to charity. Nobody in my family really is of need of this, and I'd like to make this a charitable contribution. Unfortunately, their spouse no longer has capacity and is not able to participate in making that update to leave their legacy to charity instead. We went and reviewed the durable power of attorney that was in place, and my heart sank a bit because I realized that even though I normally put those types of clauses in my power of attorney, allowing an agent to make changes to a revocable living trust, this particular client had asked for those clauses to be removed. And they said, no, they don't want that in their document. So we had removed those clauses. Now fast forward into the future, there's a change that's desired to leave things to charity, which is wonderful and generous, but it's not able to be made because the healthy spouse, who happens to be the agent for the sick spouse under the power of attorney, doesn't have the authority to make that change. And so now those changes aren't able to be made to the trust as desired, and their legacy will go to other family members who may not need the planning or the benefit of that gift. And then it will go to whoever's named in their will instead of the charity that my client had desired. So it's really important when you're putting your planning documents in place and when you're putting in your durable powers of attorney in place, that if there are opportunities to have people have extra abilities and powers, to really think about why you may want them to be able to do that for you, right? Now, they're not going to be able to make a change and include charity in their trust. That's just not in the cards anymore for them. Had they have permitted their agent under the power of attorney to make that change, then we would have a charitable gift. Is it the end of the world? Probably not. But it does make you want to pause and really think about, when you're giving your agent certain authorities, sometimes people are more concerned about losing control, and they're like, I wouldn't want somebody else to make these decisions for me. I want to be in control. And so this person, they're in control, and they're in control so much that even now, fast forward in the future, their choice may not be the best choice, and maybe they would reconsider their choice. It's too late because they don't have the capacity to make those decisions, and they didn't leave that authority to anybody else in their world to make those decisions for them. So what it is it is. So I hope that this information has been helpful to you as to how these things work in real life, why you should really consider making sure that you have comprehensive documents, and be thoughtful about if you want to give authority to certain trusted persons. If you don't, that's fine, but there can be consequences, and this is an example of some of the consequences. Is it the end of the world? Probably not. Would it have been nice to have been able to make that change and have a charitable donation? For sure. So hopefully this information has been helpful. If it has, I ask that you like and share with others. And as always, feel free to schedule a free strategy session with me at eldermeeting.com. Thanks for joining me.